Today, our topic is Right to Constitutional Remedies. Introduction. Part 3rd of the Constitution enshrines fundamental rights. The Declaration of Fundamental Rights is meaningless unless there is an effective remedy for the enforcement of the rights. एज वी नो कि हमारे फंडामेंटल राइट्स पार्ट 3rd में है कॉन्स्टिट्यूशन के। लेकिन अगर हमारे फंडामेंटल राइट्स का इन्फ्रिंज होता है या फिर वो वायलेट होते हैं, सो उसके लिए हमारे पास प्रॉपर रेमेडी भी होनी चाहिए जिनसे हम उनको इन्फोर्स करवा सकें। इट इज़ रेमेडी विच मेक्स द राइट रियल। इफ देर इज़ नो रेमेडी, देर इज़ नो राइट एट ऑल। Article 32 to 26 provides the remedy when the fundamental rights of any citizen are abridged or abrogated or violated. Article 33 state some restrictions on fundamental rights of members of armed forces, whereas Article 34 place restriction of fundamental rights while martial law is in force in any area. Article 35 state about the legislation to give effect to the provisions of this part. Dr. Bhimrao Ambedkar state Article 32 is the heart and soul of the constitution. It should be essential that there is also remedy available to citizens when their fundamental rights are abridged. Right to move the Supreme Court. Who can now the question arises who can move to the Supreme Court? Traditionally, the rule is that the right to move the Supreme Court is only available to those whose fundamental rights are infringed. The power vested in the Supreme Court can only be exercised for the enforcement of fundamental rights. Whereas a dynamic approach came, the above traditional rule of locus standi that a petition under Article 32 can only be filed by a person whose fundamental rights is infringed. This has now been considerably relaxed by the Supreme Court in its recent rulings. The court now permits the focus on the public interest litigations, more commonly known as PIL, or social interest litigations at the instance of the public spirited citizens, for the enforcement of constitutional and other legal rights of any person or group of persons who, because of their poverty, or socially or economically disadvantaged position are unable to approach the court for relief. In ABSK Sangh Railway versus Union of India, it was held that ABSK Sangh, though an unregistered association, जो कि एक unregistered association होती है, could maintain a writ petition under Article 32 for the redressal of a common problem, grievance. In the judge's transfer case, a 7-member bench of the Supreme Court has firmly established the rule regarding the public interest litigation. The court held that any member of the public having sufficient interest can approach the court for enforcing constitutional or legal right of other persons and redressal of a common grievance against whom Supreme Court can be moved. Supreme Court is the guardian of the fundamental right. It is the constitutional obligation of the Supreme Court to enforce fundamental rights, and in this process it can direct the state to take positive action. Judicial review. Now, what is judicial review? If we break these two terms, we got the idea. Judicial review. Review means when we check something. Judicial review is a process under which executive or legislative action are subject to review by the judiciary. Judicial review is one of the checks and balances in the separation of powers. The power of the judiciary to supervise the legislative and executive branches when they exceed their authority. It is a kind of check and balance system. As we all know that Article 13 deals with the laws which are in force in the territory of India before the commencement of this constitution, insofar as they're inconsistent with the provisions of this part. Of this part means part 3rd of the constitution, they shall be declared void. Article 32 is only exercisable for the enforcement of fundamental rights. Article 226 gives power to all high courts to issue writs for the enforcement of fundamental right. Now, what is the difference between Article 32 and 226? Article 32 has the power to issue writs, orders, or directions in the nature of the five writs mentioned in Article 32: habeas corpus, mandamus, prohibition, quo warranto, and certiorari, for the enforcement of the fundamental rights conferred by Part 3rd. On the other side, under Article 226, the power to issue directions, order, or writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari is available not only for the enforcement of fundamental rights but for other purpose also. Now, there are some restrictions which are self imposed on Article 32. Exhaustion of remedies is the first restriction. The doctrine of exhaustion of remedies prevents a litigant from seeking a remedy in a new court or jurisdiction until all claims or remedies have been exhausted, pursued as fully as possible in the original one. Next is about the next restriction is res judicata, which is described in section 11 of Code of Civil Procedure 1908. Under this principle, finality is given to the court of competent jurisdiction. This is done to prevent the same litigation from coming to the court again and again. However, the writ of habeas corpus is an exception of res judicata. This is an important point. Delays and laches. If any person who is not vigilant about their rights and who do sleep on their rights, the court will refuse to exercise their jurisdiction in the favor of a party. Writ jurisdiction. Now we have the five writs habeas corpus, which is a Latin term which literally means you have the body. The writ is issued to safeguard the personal liberty of a person who is illegally detained. Who can apply for the writ? A person who is illegally detained can apply for the writ, or on behalf of that person, any other person also apply. Mandamus means order. Is that thus an order by a superior court commanding a person or a public authority to perform his duty. Next is prohibition, certiorari, quo warranto.